Okay, thank you very much for joining us today. We're going to go through the labour law updates and insights for 2024 with a spotlight section on harassment and anti-bullying. My name is Georgina Petrie. I head up the marketing and BD for the Middle East for the law firm HFW, and I'm with my colleague Nick Braganza.
Hi, I'm Nick Braganza. I'm a partner at HFW. I specialise in dispute resolution and employment law. I've been based here in the Middle East in Dubai for the last 12 years, and I look forward to presenting to you today. Just hand over back to Georgina. She's going to tell us a bit more about HFW.
Perfect, thank you. So for those who do not know, HFW is a law firm. We're a global law firm with a sector-specific focus. So we focus on aviation, commodities, construction, insurance, shipping and commodities. Nick sits in the dispute resolution team, which crosses a variety of our sectors. We have more than 600 lawyers in the firm and over 180 partners. In terms of the Middle East, we've got 4 offices in the Middle East, Dubai, Abu Dhabi, Kuwait and Saudi. So that's just to give us a little background as to who we are. And this is our global footprint. You can see that we've got 21 offices worldwide, and we focus on all the classic practice areas and sectors across the world. In terms of today, we're going to focus on employment law, which is one of the areas that Nick specialises in. And we're going to then, as I mentioned earlier, do a spotlight into harassment and anti-bullying. So Nick's going to run us through the agenda on the legal updates for the labour law at the moment.
Thanks, Georgina. So as you see up on the screen, we have quite a packed agenda. Today, we're going to give a very high-level overview of the legal landscape in the UAE, looking at the differences between the various regimes. We'll talk about the recent developments that we've seen. The new labour law is still pretty new, and so we will highlight again some of the changes that we've seen. Since that was passed, we'll briefly touch on some issues that are of relevance, including Emiratisation and the unemployment insurance, the ILOE. Then we'll move on to more on the dispute resolution, starting off with employee misconduct investigations and some issues that arise. A brief litigation update, so some cases that we have seen in the offshore courts, which will be of relevance. And then I'll hand over to Georgina, who will talk to us about harassment and anti-bullying and the legal implications of that, and some more kind of practical guidance, I think, on dealing with these issues. Obviously, discrimination, harassment there hasn't, and only until recently, there wasn't that legal framework. Now that exists across the UAE, across all the UAE employment regimes. And I think it's very important that employers understand that and take necessary action to make sure that there isn't discrimination, there isn't harassment, there isn't bullying going on in the workplace. Okay, so just to move on to the legal landscape, we'll just give you an overview. Of course, in the UAE, there are various different regimes. We have 7 emirates. Within each of the emirates, we have free zones. The federal labour law, which is Federal Decree number 33 of 2021, applies across all the UAE, excluding the financial free zones. So the financial free zones, I mean the DIFC, the Dubai International Financial Centre, and the Abu Dhabi Global Markets. So those are financial free zones. Within those free zones, civil and commercial laws are disapplied. So the federal labour law does not apply. Federal labour law applies across onshore and across all the other free zones. However, those free zones may have regulations, they may have directives which will apply within those respective free zones, but under the overall framework of the UAE federal labour law. So I think that's an important distinction to be made. In the DIFC and the ADGM, that's not the case. In the DIFC and the ADGM, they have their own labour law, their own employment laws, and I've listed those up on the slides, as you can see. And so it's an important distinction to be made. In terms of the differences between the regimes, there's not a huge amount of differences between, but there are notable ones. For example, if we look at end of service gratuity, we have end of service gratuity onshore under the federal labour law. So end of service gratuity is the payment that must be made to employees when they are terminated. Within the ADGM, end of service gratuity applies. However, within the DIFC, it does not. In the DIFC, we have the DIFC Employee Workplace Savings Scheme. This is more like a pension that we would see in more Western jurisdictions, a pension scheme whereby employees and employers can make contributions. There are investments made with those funds, and they will hopefully make a return. And then at the end of the employment, the due scheme goes on. So if you move to another employer within the DIFC, for example, your dues entitlements will be transferred. If you leave the DIFC and go and work onshore, then they will be paid out, or they can be kept in and kept as an investment. Other key differences, of course, since the changes to the labour law, we have now fixed-term contracts. Fixed-term contracts onshore are limited by 3 years. We don't have the same within the DIFC and the ADGM. Notice provisions, they are different within between onshore and the financial free zones. Within the notice period that you need to give when you're terminating an employee, there's a difference. If in the DIFC and the ADGM, if you have an employee who has worked less than 3 months, they are entitled to 1 week's notice. If they work between 3 months and 5 years, they get 30 days. And if it's more than 3 months, up to 5 years, they get 3 months if it's more than 5 years. That's within the DIFC. Onshore, there is notice, and it's not less than 30 days. So after the end of your probation for your employee, they will be entitled to 30 days notice up to 3 months notice. Of course, all these provisions can be varied under the terms of an employment contract, but generally these are the protections that we have. So there are various other differences I've written up on the slides. For example, there are differences in sick leave. Under the ADGM, and the DIFC, you can have up to 60 days sick leave, whereas onshore, outside the DIFC now, onshore, outside the DIFC and ADGM, can have up to 90 days. So there are differences, there are slight differences, but nothing too significant. In terms of the payment of termination benefits, those must be paid whether you're onshore in the DIFC or the ADGM within 14 days. Next slide, please. So if we look at some recent developments, we've obviously had the changes to the employment law in 2021. We've also had various developments which are important and must be considered, such as Emiratisation. Now, Emiratisation applies to companies in the private sector, more than 50 employees, and they must have 2% UAE nationals within their workforce. So that was in place from, the 1st of January 2023. Only applies to the private sector companies registered with the Ministry of Human Resources and Emiratisation. Doesn't apply within the free zones. 2% of the company's workforce increases year by year up to 10%. Failure to comply with these provisions will result in fines. And we know that the Ministry of Human Resources and Emiratisation is very active in monitoring companies' compliance with these provisions, and many companies, many companies who I've spoken to have been fined. So it's very important that you comply with your obligations, and you can get your guidance from the Ministry of MOHRE on this. Another recent development is the unemployment insurance. So the ILOE, Involuntary Loss of Employment Scheme, which was established in October 2022. From the 30th of June 2023, all employees in the private sector must comply with this. So this is mandatory for employees in the private sector outside the free zones. Again, so this will apply outside the free zones, that employees must sign up to this scheme. It's an insurance scheme for people who are out of work. So employees who are paid less than 16,000 dirhams per month must pay 5 dirhams per month. If it is more than 16,000, they must pay 10 dirhams per month towards this employment insurance scheme, so that when they get out of work, they can call on this scheme and get unemployment benefit, we would call it in maybe some Western jurisdictions. And they can get up to 60% of their salary when they're out of work for a period of 3 months. And that is up to a maximum of 20,000 dirhams per month. So an employee who's out of work can get up to 60,000 dirhams by signing up to the scheme. In terms of the obligations on the employer, it is not mandatory. There are no sanctions on the employer if their employees don't sign up to the scheme. There is obviously the sanction or the disadvantage on the employee, because they won't be able to take advantage of the scheme. But there is no sanctions for employers if they don't get their employees to sign up. Sorry, I'm just on the changes that we have seen to the labour law. There are quite a few changes. There are quite a few changes. Of course, the previous law was passed in 1980. So in 2021, finally, there were many amendments to the labour regime onshore. I've touched on one of them. The employment contracts must be switched to fixed-term contracts of up to 3 years. It doesn't have an impact on the accrued benefits or the notice provisions or the end of service gratuity that an employee would be entitled to. And it's difficult to understand why they have removed unlimited term contracts. We suspect it's to keep employees and employers' contractual framework updated, so that every 3 years at least, that the employees are reminded of their rights, that the employers are reminded of their obligations to the employees. And so then on a regular basis, those employment contracts are updated. So they are fixed term contracts, which now exist under the new labour law. Probation is an important one. Previously, it was very easy for employees to disappear during a probation period. Now they need to give adequate notice. So as previously, as is common across the UAE, many employees, once they start working for a new employer, are put on probation. Now, an employer can put an employee on probation for up to 6 months under the labour law. And they can, during that probation period, it's much easier to terminate them. And if you want to give notice to that person, you can give only 7 days notice. If an employee wants to leave an employer in Europe during a probation period, if they are staying in the UAE, they must give at least a month's notice before leaving. Furthermore, a new employer must compensate. So if an employee leaves one employer and goes to a new employer of someone he's recruited, and there have been costs associated with employing that person, recruiting that person, I should say, things like visa costs, if you have paid for that person to come from overseas, and travel costs. Those kind of costs can be recovered by the ex-employer, and they can go to the new employer to bring a claim. And I have had this recently, and it was relatively straightforward. I think many employers are aware of their obligations. If they recruit someone while they're in their probation period in another company, they will be able to recover their costs. The position is different in the DIFC, interestingly, where a new employer will not be held liable for those recruitment costs, but the employer, ex-employer, may hold the individual responsible for those recruitment costs. So it's a difference between onshore and the DIFC in that respect. In terms of, there are lots of changes with respect to leave. Under the old law, there wasn't a lot of, provision for example, for parental leave. Now we have maternity leave, which has been extended. We have paternity leave, which has been established for the first time. Now, fathers can have 5 days paid leave, whether they are in the DIFC or ADGM or onshore. The parental leave must be taken onshore within the first 6 months, offshore in the DIFC within the first month, actually. So the provision for maternity leave onshore has been doubled. Now we have 60 days. 60 days having arisen from 45 days for maternity leave, 45 days at full pay, 15 days at half pay. There's slight changes with the other. Sick leave, we've talked about. Study leave, compassionate leave are all provided for under the new employment law. An important change that we have seen is to do with, and we'll talk about this a bit more when we talk about litigation, is summary dismissal, unlawful dismissal. Now, someone can be dismissed for certain reasons under, I think it's Article 47 of the law, which provides for various reasons why someone can be dismissed, which replaces the previous Article 120 of the old labour law. But dismissal will only be deemed unlawful automatically if an employer terminates someone while after they've made a complaint to the Ministry of Human Resources and Emiratisation. There must be a legitimate reason to terminate someone, but you can terminate someone relatively straightforward, provided you give them notice. So you give someone notice to leave, and the notice provisions will be as per the contract or as per the law, which I touched on earlier. But they can be terminated relatively straightforward. If they challenge their termination, there are reasons that they can be terminated without notice for cause. They may challenge that in the labour court, but the total risk to the employer is that they will just be all obliged to pay the notice period. Those provisions related to compensation have very much been pared down. I think what we can say about the changes is that the UAE has shown itself to be, with respect to these changes to the labour law, very friendly to investors. They, in my opinion, are quite pro-employer. Of course, they are increased rights for employees, but they are generally quite pro-employer. Employers can terminate now, provided they give notice, provided they pay all the end of service maturities and all the other entitlements to the employer is due. that they can terminate the employees. And previously what we had was there were challenges with terminating someone. So I think these are generally positive for employers. Okay, next slide. Good. Okay. So, so we've talked about the framework. We've talked about the changes to the employment law and the differences. Now we're going to get on to more around the dispute resolution, more around employee misconduct and how to deal with it. I think at the outset, it's important that there is a process around dealing with employee misconduct. It is not good enough for you to terminate someone. Although there's changes, as I've just talked about, it is important to treat employees fairly during a misconduct process. That may include putting them on suspension, so suspending them from work on full pay while you conduct an investigation into the misconduct. There is important to set a process and communicate with the employees. Sorry, it's important that you communicate with your other employees about the process and think very carefully about what you say and don't say when you're conducting an employee investigation. It's you need to have the opportunity for the employee to explain their misconduct. I've had a case recently where an employee was terminated for cause and with good reason, I think. His complaint, and this was actually a claim in the DIFC rather than in the onshore court, but his complaint in the DIFC was that there wasn't a fair process. He was terminated. He was put on suspension at full pay. He was put on suspension on full pay for a long period. He got his full pay, he got his full entitlements. But he claimed there was not a fair process after he was put on that suspension during that investigation. And the court ultimately found that it wasn't correct that he was terminated for cause. And part of that reason was that there wasn't a fair process around that. So it's very important to put a fair process. Disciplinary processes must be documented. There must be policies in place so employees have visibility. Whistleblowing is a perennial question. Whistleblowing is obviously very prevalent internationally. And having a mechanism in place for employees to report wrongdoing in the workplace remains the single most common, best option for uncovering employee misconduct in our experience. I would say 70% or more of our employee misconduct investigations start by whistleblowers. So it's important to have a framework, important to have a mechanism, whether it is that there's a hotline, or that there is a channel by which employees report that. But of course, in this jurisdiction, there are issues around whistleblowing. Employees are often afraid to whistleblow because of repercussions. Repercussions may include defamation. Defamation is much more broadly construed under UAE law, meaning that an employee who is reported, so the person who is the suspect, as it were, could report that person to the police and say he is damaging my reputation. So generally we've seen whistleblowing happening less. We've also seen employees' reluctance to whistleblow because of the repercussions from their own employer. Employers like burying their head in the sand and don't want to hear about it sometimes. This is not appropriate, and it's important that whistleblowing is promoted and you have policies in place around it so that that can be a channel for you employers to uncover misconduct in the workplace. When you're conducting your investigations, for example, fraud or misappropriation. So someone's doing deals in the back door, you know, or someone is putting their hand in the till. Often you need to conduct that investigation, and that investigation may include reviewing people's personal devices, employees' personal devices and laptops. Now, this is an issue that we come across very regularly. There are challenges from a privacy perspective of asking an employee to look at their WhatsApps if those WhatsApps are on a personal phone. And it is justified for an employee to resist that. You know, the law is constantly changing, and we may see changes in that. But if it's on a personal device, it's difficult to ask for that employee to hand over that phone. We've had instances where even though an employer had a policy which employees were asked to sign, saying that they would hand over their personal devices, employees resisted and did not hand over in an employment misconduct investigation, which I conducted. The employees would not hand over their phones, and they probably wouldn't be compelled to do so by the UAE courts. So the way that we deal with that is by having work phones. If you have work phones and work laptops, that's much easier. If a person has a work laptop or a work phone, you can ask them to hand over that device. And if they've been conducting their side deals or their dodgy deals on their work phones, we'd have much better chance of being able to look at those devices. So that's one to bear in mind. You know, there are some who may say that WhatsApp is by its nature personal and may still resist that review. And there are challenges with that, but you can help yourself by having the work phones issued to your employees. You can help yourself by having policies and procedures in place to make sure that employers have the right to review WhatsApps or whatever. Because in this part of the world, you know, even more so than elsewhere, business is conducted by WhatsApp, and so it's very important that you have the right to review that. I just put remedial action to be taken. So often when we're conducting investigations and I'm working with my clients in conducting those investigations, we give various recommendations at the end. They may conduct that investigation, but it's imperative that employers learn their lessons. It's not good enough to just bury your head in the sand, sweep the misconduct under the carpet, terminate all the employees, sorry, excuse me, and hope that it doesn't happen again, because it will. Because if you have a culture whereby this conduct is not challenged, if you have a culture where remedial steps are not taken, things will happen. You need to have controls in place. You know, why was that employee able to make those kind of withdrawals from the office bank account without the necessary controls in place? You know, why did those employees blindly follow their manager? Why weren't they checking that what that was going on was not authorized or not permitted? You know, it's important to put those controls in place so that we avoid employee misconduct happening again. The last point is something quite specific that came up, and you know, you may have labour claims which follow an investigation. So if you terminate someone at the end of your investigation and they file a claim against you, you won't be able to cancel their visa, or you shouldn't cancel their visa pending those claims. It is possible for the new employees to ask for a no objection certificate so they can commence work for their new employer. And this issue came up recently, and there'll be a case which I'll talk about next. We're going to switch into the DIFC and ADGM this next section. The majority of my employment work is actually litigation, where I am acting for employers or employees in proceedings in the DIFC courts. The good thing about the DIFC courts is that a lot of their cases are very public. You know, it's possible to review the judgments, whereas I'm sure there are always certain challenges. You know, the new employment law, although it's a few years old now, is still relatively new. We have still yet to see that full range of court cases which follow to see how the new law is being applied. But we can see how the DIFC law of 2019 has been applied, and one of the key provisions under that law was that refinement of the penalty provisions. In the DIFC employment context, if you terminate someone, you must pay them their end of service gratuity. You don't have end of service gratuity, their entitlements within 14 days. And if you fail to do so, the employer may be held liable for and apply a penalty. And that penalty is calculated by reference to the daily wage of the employee. And that can go for many years. What they have done now is restrict that number, so it only starts from the time that the 14 days period expires, up until either it's paid or until the employer's filed his claim in court. But we've seen a number of cases. Many of these cases which I've listed, I myself have been involved in, and we've had differing results in terms of whether they've gone in favour of the employer or the employee. With respect to the Tarek Remteller case, the employer withheld paying its entitlements because the employee owed the employer money. So the employer granted an employee loan and hadn't repaid that. There was various other payments that were due from the employee to the employer. So the employer didn't pay some of the end of service entitlements. The court said no in this case, and it went all the way to the Court of Appeal within the DIFC, and the Court of Appeal said that the employer had to pay the entitlements. If the employer had a claim against the employee, it needed to make that separately and in good time. There was no automatic offsetting that was permitted. And I think that's an important point. It probably would apply onshore as well. So the employment entitlements must be paid within the 14-day period. The second case is a case whereby the employee filed a case for malicious prosecution against the employer, and the employee filed a case for its entitlements and huge penalties. And these penalties were from before the law was amended, and many millions of US dollars, many millions of dirhams were claimed. Ultimately, the court did find that the penalties were payable, but it rejected this malicious prosecution, and the malicious prosecution resulted from the employer filing a criminal complaint against the employee, and the employee said, hang on, you shouldn't have filed this this criminal complaint against me. The public prosecutor rejected that, but in that case, the DIFC courts would not award damages for malicious prosecution. Faisal Babu's case, another one that I was involved in, a recent success. We got judgment a couple of months ago. This case, an employee was terminated for cause, and it was what I was mentioning in my last slide. He was of full pay, but he claimed he made various claims resulting from entitlements during his suspension. So he was claiming things like his school fees while he was on suspension, his flights home. Actually, all those claims were rejected. His claims for penalties were also rejected. But the main reason that the court found that those claims were rejected was because he didn't bring his claims early enough. He brought those after the 6-month period. So under the DIC employment law, you must bring claims within 6 months, and he failed to do so. The last case was, again, the case I previously mentioned, was about an employer who refused to cancel the visas of its employees. This employer determined that a bunch of employees had left together to join a competitor. And in order to prevent them joining a competitor, he didn't cancel their visas, and he filed absconding orders against them. So he said that they had run away, and so there should be travel bans applied. Actually, here the DIFC authority did apply travel bans to these employees, and the court said that that was wrong. That if you have claims against an employee, you must make those claims, and that's very much what we saw with the Tariq Ramtella case, that you shouldn't use the travel ban tactic as a tactic to apply pressure on your employees. Actually, I'm in court this week on another case where we have seen some interesting tactics taken by an employer to prevent employees moving to a new employer. This employer was onshore, and they were moving to a DIFC company. So they're moving from onshore to offshore. The employer filed criminal proceedings against the employees. They filed labour claims against the employees. Those were all rejected. Now the ex-employer has brought a claim against the new employer. I am representing the employees, and they are dealing with claims for misappropriation of confidential information, which may result in some contempt of court for those employees, and we're resisting that. So it'll be an interesting case to see what happens. Just to briefly touch on the ADGM. The ADGM is obviously much smaller and less developed, I think we can say, than the DIFC, but it has the majority of the cases which seem to be going through the ADGM courts are related to employment. Interestingly, in the ADGM, there is no cap on penalties. As I mentioned earlier, there is no cap on the DIFC employment penalties. There is no cap, but an award of a penalty must be just and equitable. What we've seen as a much more conservative approach by the ADGM courts, the Abu Dhabi Global Markets Court, to the awarding of penalties where an employer has failed to pay employment entitlements at the end of employment. Good. So I'm going to hand over to Georgina, and she's going to talk about our spotlight issue today, which is harassment and bullying.
Thank you. So Nick has provided a really good framework as to the labour law, how everything works, the recent updates. So we thought we'd just take one particular incident as a bit of a spotlight session, look at how this would play out within the current law as it stands across the various jurisdictions, whether it's onshore, the IFC or ADGM. So the overview of this section will be looking at providing an overview of harassment and bullying in the context of some relevant legislation. We're going to understand more about what harassment is, what could be constituted as harassment and bullying in the workplace, and things that could be considered as harassment. This will lead us on to the types of harassment and discrimination. We'll then further look on at what is bullying, and then understand how the potential legal implications of harassment and bullying can be affected within the workplace. And then we'll look into the reporting concerns, how the process and the process for investigation, and that leads into the policies which companies should have in place to safeguard employees during their employment. So in terms of establishing what harassment is, this is a sort of very succinct idea as to, prescriptive way of what harassment is. So harassment is any unwanted physical, verbal, or non-verbal conduct, and that includes a single incident that has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. This also includes treating somebody less favourably because they have submitted or refused to submit to such behaviour in the past. So as referencing before, a single incident can amount to harassment. So there are lots of various elements that contribute to harassment, and we'll follow that up in more detail shortly after we just look at harassment and discrimination in terms of the UAE law.
Thanks, Georgina. I think, there's been quite a revolution with respect to discrimination and harassment in the workplace since the new, actually before. There are claims that employees can make against their employer in the labour courts, but there are also criminal implications for harassment, which were always there maybe in the background under the provisions of the penal law, but a bit vague, and nobody really followed up. Now there are specific laws dealing with discrimination and specific laws dealing with harassment. So there can be serious implications for employers and those perpetrating the discrimination and harassment. And so that's important to see. So we've got the labour law, as I said earlier, it's been amended since 2021. This prohibits discrimination on the basis of race, colour, gender, religion, nationality, social origin, or disability. So this prohibits sexual, physical, verbal, and psychological harassment. Female employers are entitled to be paid the same as male employees. There is a prohibition on the termination due to pregnancy or maternity leave. So we have big protections there for employees from discrimination in the workplace. There is also a separate law on people of determination and protection for those people. Go to the next slide. We've also got the law combating discrimination and hatred, which was passed in 2015, which makes this a criminal offence for any form of discrimination by any means of expression or by any means. So there are penalties that can be applied by the ministry. There are also claims that can be brought by employers. They will have to file a complaint with the ministry, but then that can result in employees bringing claims in the labour court. And if they have had to leave their employment because of discrimination or because of harassment, they may be able to claim compensation. The penal code, which is the criminal law, was also amended in 2021, and various offences have been identified. So that can result in the police and the public prosecutor taking action against individuals who perpetrate these crimes.
Thank you. So one thing we often get asked is what can be constituted as discrimination or maybe even feedback. So if your colleagues make comments or take actions against you that are based on your race, colour, ancestry, place of origin, your social origin, religion, marital status, physical or mental disability, or gender, this is considered harassment. I do appreciate that's quite a long list, but all of these areas must be looked at and must be considered when looking at discrimination. In terms of feedback, if a manager asks you about a project that didn't meet the deadlines or a fact that you're always late to work, this doesn't necessarily constitute, well, it doesn't constitute as harassment, although you may not feel comfortable in a particular situation. So there is the slight distinction between feeling uncomfortable because something's maybe not up to the standards expected, or harassment. And that's why we'll look more at harassment and discrimination now. So in terms of a practical understanding as to how this might play out in an office, in the workplace, and it's worth noting that it's not actually only confined to the workplace, it's actually outside of the workplace as well. So harassment can be considered physically blocking a person's movement, standing in their way, not letting them walk past, making them feel uncomfortable in that way, accidentally on purpose brushing up against the person or making an excuse to touch them for no reason, following them around and paying excessive attention. So sort of unprofessional, not warranted attention. The classic telling lewd jokes or sharing stories about someone based in their race or religion, even if it's not directed at the person but done within the presence that can cause discomfort, that is also an element of harassment. Likewise, sending unwanted, suggested or lewd emails, letters or communications, whether it's on Teams, whether it's on WhatsApps, whether it's on emails, over the phone, in person, behind somebody's back so that they can hear. All of that is not appropriate and considered as harassment. That includes sharing images of a sexual nature around the workplace, putting posters or screensaver offers of a sexual nature. Particularly out in the Middle East, it's something we must be more careful of and should be taken more seriously. And as Nick was saying, there are more laws now safeguarding employees and also ramifications for those who overstep the mark. Another element of this is making offensive gestures, remarks, or facial expressions in relation to someone's race and religion. And that also ties into any disability, their sex, their race. So there really isn't an exhaustive list on this. Types of harassment and discrimination. There's 5 key elements that we're looking now. The first one being racial. So this is prejudice, discrimination or antagonization by an individual, community or institution against a person or people on their basis of a membership of a particular racial or ethnic group, typically one that is a minority or marginalized. Pregnancy. Again, this is one that's something Nick touched on earlier. So the type of employment discrimination that occurs when expectant women are fired or not hired, and that's either they're discriminated against due to their pregnancy or intention to become pregnant, or they're on maternity leave. And the law now provides stronger and more regulated provisions to prevent all of these types of harassment and discrimination. In terms of sexual discrimination, it's discrimination against the person on grounds of sex. In terms of disability, as Nick said, there is a completely new separate law that does safeguard those with a disability or people of determination. And that disability discrimination is when you are treated less well or put at a disadvantage for a reason that relates to your disability. The 5th one that we're going to look at today is religion. So this is when religious discrimination is treating a person or group differently because of their particular beliefs in which they hold about the religion. As I mentioned, there are many other areas that I spoke of at the beginning that can constitute to harassment and discrimination, but we're just focusing on a few elements today as we've got quite a lot to get through. Moving on to what is bullying. Now, this is slightly different to harassment, and you'll see that there's a bit of a play of power on it. So bullying is termed as being offensive, intimidating, malicious, or insulting behaviour involving the misuse of power. This includes, but is not limited to, the use of position of authority, personal strength, and or the power to coerce through fear or intimidation. And this can make a person feel vulnerable, upset, humiliated, undermined, threatened. And this also includes, but not limited, physical or psychological threats. There will be physical harassment, there will be psychological harassment. It's all are now have provisions for them in the law and the ramifications which companies should be looking at to safeguard employees. And likewise, we'll go through the reporting and the ways to tackle that through your policies. Everyone should adhere to the policies, and just for general good conduct, let alone being safe in the workplace and outside of the workplace. But bullying is generally slightly more of a power trip, for want of a better word, but again can have physical or psychological problems. So examples include spreading malicious rumours, unfair treatment, picking on someone unnecessarily, constantly, or even a couple of times or just once, undermining someone, denying someone's training or promotion opportunities based on their race, religion, colour. You know, all of these things play a part. And as I mentioned earlier, it can be face-to-face, by letter, email, phone, social media, LinkedIn, Instagram, WhatsApp. All of these are still part of, or should the policies do cover, and, you know, so harassment can happen inside the workplace and outside of the workplace if it's involving employees. So to safeguard your employees and to safeguard yourself, something that we'll talk about at the moment is the employer really must make sure that they act on these issues. We'll come to that in a second, but to prevent issues and to have a framework in which the employer should work, here are a couple of elements that should be included within a policy. So the company shall not tolerate any workplace violence, harassment and or bullying committed by or against employees. And then that doesn't extend just to those in the office. It employs to officers, agents, representatives to countries and third parties. The policy should also add that employees are prohibited from making threats, engaging in violent activities, harassment and or bullying, whether at work or inside or outside the workplace. And in the case of harassment or bullying, whether a person is online as well. So there's very many ways it can take place. The company should also encourage employees to report concerns to their immediate supervisor, management or HR. And it's at that point that the company must follow up and must take swift and decisive action on these, which Nick will talk about shortly. The company should also not tolerate any form of retaliation, intimidation or victimization against a person that makes a complaint or participates in an investigation in good faith. Now that means that, again, it's safeguarding the employee that these bullying, harassment should be reported, and the company should provide a framework in which that report is dealt with. So just turning to the reporting and investigation to wrap up the spotlight, Nick's going to look at the reporting, procedure and the outcomes.
So this would also be in your policy. You need to have a procedure in place as to what you should do if you are bullied or if you're harassed in the workplace. So there should be how to report. Now, a report of any threat or immediate danger should be reported to the Dubai police. Now, this is serious. You know, once you get the police involved, you as the employer would probably lose control of that situation. Of course, though, if it is very serious and someone is in immediate danger, then they should report it to the police. But what we should encourage our employees to do is actually report instances of actual of dangerous situations or suspicious misconduct or relating to harassment or bullying. Should be reported to your line manager or to HR. And I think that it should be, and what I always tell my clients and HR professionals, is they should maintain control of the situation before we get outside influence, before you go to the police or go to the courts or whatever else. Try and resolve these situations within the organisation. So if you can encourage your employees to report this misconduct to you, then you should, then an HR should conduct an investigation into this, and that investigation should be conducted thoroughly and promptly. Confidentiality should be maintained, of course, because of the risk of defamation, the potential for serious ramifications for the person accused. So make sure that you keep it confidential, and the possible outcomes, which may include disciplinary action, which may include termination of that employee, and there would be grounds to terminate that person if they've been found guilty of harassment or bullying. I know we're running out of time, so the obligation to report under the penal code. Yes, does an employer have the obligation to report misconduct or harassment or bullying to the police if it is found that it has happened? It's a difficult question, and I think it should be considered on a case-by-case basis, but there may be certainly circumstances where you have an obligation to report misconduct to the police or even to the ministry, but we can talk about that. Anyway, thank you very much, and it's a whistle-stop tour through the employment regime in the UAE. You have my details up on the slide, and Georgina's as well. If you have any questions, do not hesitate to get in touch. I don't know, Shivani, do we have any time for questions now, or shall we take those offline?
Hello, Nick. Thank you so much, Georgina and Nick. Definitely. So we do, I mean, we have run out of time, but we have multiple questions. If we can just quickly take them.
Okay.
Yeah. Okay. I'll go with the first one. Is there any obligation ILOE expects from employers in any way during employee service time or after leaving? Do we need to have an ILOE corporate account? Is there a registration window directed to employers?
That's quite a lot of questions. In terms of the ILOE,
I can go one by one if you want.
No, that's, I mean, in terms of the ILOE, the obligation is on the employees, not the employer. The employer is not under an obligation to register.
And they register themselves.
The employees must register themselves. It's up for employers to encourage their employees to apply and to apply to the scheme, but there's not an obligation, as far as I'm aware. I have to profess I'm not an expert on the ILOE scheme, but my understanding is there's no obligation on employers.
Great. Moving on to the next one, the person wants to know if the probation period for expat versus UAE citizens is same, which is 6 months.
Yes, it is the same. However, there is a difference between the notice period that an employee must give. So under the law, which I'm not really sure I understand why, but under the law, if an employee is staying within the UAE and moving to another employer within the UAE, they must give at least 1 month's notice. However, if they are an expat and are leaving the UAE, so they come to the UAE and they're leaving within their probation period, they must give 14 days notice to their employer before leaving. So that's the difference. But in terms of the probation period, it's up for employers to determine the length of the probation period. The law provides a kind of maximum of 6 months. But it's up for employers to determine how long that probation period may be. It may be 1 month, because it's easy for employees also to leave within the probation period. So better to get to the end of your probation period, then proper notice must be given both by the employee and the employer. So it needs to be determined on as to your business needs. But the law specifies that 6 month period.
Lovely. Okay, moving on to the next one. What can we do if we have a case of rumor spreading about an individual and it comes to a point of it starting to harm one's mental health and is getting bullied indirectly?
Do you want to?
I'll probably say the same thing.
Yeah.
I think so. It comes into the reporting line. Like, it needs to be raised with HR. The firm should have the policies in place. HR should deal with that correctly, and then the full investigation should take place.
Bullying is bullying, you know, whatever form it takes, whether it's behind the scenes or under the radar, and it's having an impact on someone's mental health, that needs to be taken seriously by the employer, and they need to be conducting investigations and determining whether or not disciplinary action needs to be taken. It's not good enough just to turn a blind eye.
And it's not just physical as well.
Yeah.
Exactly. Okay, great. The next one is, for those without a company agreement or contract, do we need to issue closed contracts for all employees without it dated for 2 years using the MOHRE contract dates? Does this mean we also need to issue a new contract to all employees internally each time it expires, or is a one-shot contract, then we rely on the MOHRE renewed contract every 2 years when it expires? Let me know if you want me to repeat the question.
A complicated question. Yeah, if you just repeat it, please.
Okay, I'll go step by step. For those without a company agreement or contract, do we need to issue closed contracts for all employees without it dated?
Sorry, so Shivani, by closed contracts, do we mean fixed term contracts?
Could be, yeah.
Yeah, there's the obligation, there has to be a fixed term contract, but carry on.
Okay, so yeah, so that answers. It says a closed contract for all employees without it dated for 2 years. I mean, which means that it does not necessarily have to be for 2 years. Can it be a open contract?
Yeah. No, it has to be it has to be a fixed term contract. You can't have limited term contracts now on the new labour law. You need to have a fixed term contracts, and they can go for 3 years. But you need to be renewing those contracts on a regular basis. I'm not sure I fully understand the question, but I think the answer is that yes, you are obliged to have fixed term contracts for all employees if you are onshore.
And I believe we have answered the next part of the question, but I'll still go through it. Does this mean we also need to issue a new contract to all employees internally each time it expires? Yes, of course.
Yeah.
Yeah. Or is a one-shot contract, then we rely on the MOHRE renewed contract every 2 years when it expires?
Okay, now I think you need to have a fixed term contract that's renewed on a regular basis.
Right. Okay, great. Let's move on to the next one. What is the notice requirement for cases around role structured or redundant to avoid court claims?
So, sorry, I didn't quite get that. Say that again.
What is the notice requirement for cases around role restructured or redundant?
Okay.
Yeah. To avoid court cases.
It's the same under the what is provided for under the law, or what's provided for under the contract. So you must give not less than 30 days, not more than 90 days for after the probation period is finished. So that's the notice. So whether you are terminating someone for misconduct, or you are terminating someone for redundancy, redundancy now is provided for as a justifiable reason for terminating someone's employment. If someone's role has become redundant, you must comply with the law, so give them the adequate notice, which, as I said, can be between 30 days and 90 days. or as provided for under your employment contract. You must pay them all their entitlements at the end of their employment. But in order to, and thereby you would avoid claims. A person cannot have a claim against you if you comply with those notice provisions and you pay them their entitlements. Does that make sense?
Right. Yeah. Okay, the next one, I'm sorry, I'm going a little fast considering we are running out of time. So I'll move on to the next question. What are UAE rules if employees are forced to work for longer hours than the normal time? Employment contract does not cover the provision for overtime payment during normal weekdays. So contract mentions 9 hours normal work day, while employee are forced to work for 12 hours and more during weekdays.
So what's the question? So
that if there are any rules,
what's the actual question on that?
If there are any rules, yeah, if the employees are forced to work for longer hours than the normal time.
I'm not sure on the answer to that. I need to check what the law says on overtime. There is provision for overtime under the new labour law, but I'll need to check what the law says. I'm afraid I don't know the answer to that immediately, sorry.
Okay, the next one says, UAE government recently announced a new law encouraging diversity with work permits to avoid rejection of these. If we ask leaders to hire less of a certain nationality to help this drive of diversity and avoid work permit rejection for this nationality, are we being discriminative for mentioning this nationality?
You need to be very careful when you are recruiting, and if you are specifically referring to certain nationalities, that's not sensible. I think the exception, obviously, is Emiratis, because now private sector employers are under an obligation to recruit Emiratis. With respect to any other nationality, I think you need to be very careful when you're recruiting, when you're restructuring your workforce, when you're doing anything and referring to nationality. If you are recruiting people purely on the basis of nationality, I get the difficulty, because yes, there are obligations to have a diverse workforce, but you can't be seen to be discriminating against certain nationalities when you're recruiting. So you can't be prescriptive, you can't be openly saying that to the market.
Right, exactly.
So it was done many years ago, and it's probably a bit of a hangover from previous years. Certainly when I moved to Dubai 14 years ago, that was definitely seen in Gulf talents and Beirut and these types of things, but no, it's not appropriate now.
Right. Okay, we'll take the last question for today. What if we report to our local HR or manager and the bullying still continues? Shall we take this into consideration for the law and labor?
So as an employee, if you report it to your line manager and your line manager does nothing, I think we have
if you report it to HR as well, and there's nothing that
HR, nothing's happened, then you will have to file a complaint with the Ministry of Labour, the Ministry of Human Resources and Emiratisation. Of course, that could have serious implications for you, but if you feel that you have a justifiable concern that's not being dealt with, if anything happens to you, obviously the Ministry of Labour may take steps against the employer. If you are terminated or you are forced to leave your work, you may have a claim for bullying or harassment. So as an employee, yes, I think you would have to report it to the ministry, because if your employer is not taking steps, that must be the only way to go.
And these are why these provisions have been brought in to allow that.
Absolutely.
Yeah, that's good to know. Okay, we have one more question here. We'll quickly take that one. Is there any legal implication to employee/employer for delaying fixed contract visa renewal?
Is there any justification for delaying?
Implication. Is there
Implication.
any legal implication
Yeah, I
to
think there can be
employee?
some. Again, my understanding is that you can be subject to fines if you aren't renewing, putting people on the fixed term contracts, and they can cause problems when you are, for example, renewing your license or whatever else. So there can be legal implications, certainly.
Right. All right, Nikin, Georgina, it was a lovely, lovely session, and I love the fact that it was so detailed, and we touched on every possible topic today.
That's great. No, it's a pleasure to present today, and I hope it was helpful.
Yeah, you're very welcome.
Okay, thanks a lot for your time, and I hope to speak to you both super soon. And thank you all for taking our time and attending this session today. I am quite positive that you learned a lot, many things. I know it sounds very basic when we are, like we know that we know all this, but when there's so many things that we learn new in such sessions, I personally feel.
Good. Glad.
Thank you for joining, everyone.
Yeah, thank you. Thanks a lot. And hope you have a great day ahead.
Thank you very much.
Thank you. Bye-bye.
Bye.